first one is a foundational issue. The second one is the 702 Daubert issue, and that's completely created because of the state. And the third one is an identification issue. And I say it's an identification issue, I'll jump ahead just a little bit. We believe that these alterations or these modifications, changes were made so the state can bolster Detective Shephard's testimony that the person they circled, the person that they followed, is the person that actually killed that young girl. That's why there's an identification issue that we must address. But first, when it comes to a foundational issue. Under Georgia law, generally a videotape is admissible where the operator of the machine, which produced it, or one who personally witnessed the events recorded, testifies that the videotape accurately portrayed what the witness saw take place at the time the events occurred. This is why we have to ask those questions, is it a fair and accurate representation of what you received? Investigator Teague, when asked those questions, said yes. That's why we went to the next step. But then when we found out that there was stuff on that on State's Exhibit 2 that he didn't receive, he didn't get from the 3 locations somebody else did, that he just saw later, that was a huge problem. If they want to admit videos, Your Honor, the person they're trying to admit it through has to say, yes, this is an accurate and fair representation of what I perceived, what I received, what I saw, or what I recorded. Now, I believe it's a position of the defense that because of the steps that multiple people that are a part of the state took, there isn't now a single witness that can answer those questions truthfully. And I say that because, again, we get it. They can't bring in anybody from the 3 locations because all they gave was the raw video. So that new altered stuff, they can't say, yes, this is accurate representation. It's not what they gave. Detective or Investigator Teague can't say, yes, this is what I was given because we know now it was altered. We believe Detective Shephard can't say, yes, this is an accurate representation of what I was given because it wasn't. We know he made alterations himself and then it moved on to their graphics department. We don't know how many people in the graphics department touched this. We don't know what they did with it. And I'm going to get to that in a minute with the 702. But as of right now, this has passed through so many hands from the quote-unquote raw video that the state was talking about that what they're trying to get in now, there isn't a witness that they presented to us, that they told us about, that we've been able to speak to, that can say, yes, this is a fair, accurate representation of what I received because it's been altered, changed, and modified so much. I'll try to streamline this as much as possible.
You're fine.
Now, issue 2, which is the 702 Daubert issue. I'd first like to address, bring to the attention of the court, Mitchell v. State. I know I gave you a copy of this a couple of days ago, but that's Mitchell v. State, 320 Georgia, 673, a 2025 case. Under Rule 701A, a lay witness may testify in the form of opinions or inferences that are rationally based on the perception of the witness, helpful to clear an understanding of the witness's testimony or the determination of a fact and issue, and not based on scientific, technical, or other specialized knowledge. And as the court's fully aware, because we're in Georgia and we're a rule of evidence, now we're under 24/7 702 and the Daubert standard. And I bring up the Daubert standard, Your Honors, because again, we're not talking about just the raw footage that was given from those 3 locations. Alterations, changes, a lot has been done with these videos to get to what the state's trying to introduce now. A lay witness can't come in because, again, we still don't know how it got from point A to point B to point wherever we are now. So now I believe they have moved all of this, if they're going to try to introduce it, to the Daubert standard because there's some type of other specialized knowledge that was put into these exhibits and into this evidence that didn't exist at the beginning. We have to have a whole hearing about that. Now, the admissibility of expert testimony in Georgia, like I said, is governed by 24/7 702, which provides as follows. If scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact and issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise if the testimony is based upon sufficient facts or data, the testimony is a product of reliable principles and methods, and the witness has applied the principles and methods reliably to the facts of the case which have been or will be admitted into evidence. So not only does their witness have to be able to lay the proper foundation that what they received is actually fair and accurate? They also now, because they manipulated and altered it so much, they have to be able to, under the 702 Daubert standard, lay the foundation that not only what they did is reliable in the methodology they use, but they used it reliably in this case. That has not been done yet. Detective or Investigator Teague is not in a position to do that. None of the people from the 3 locations is in a position to do that, and we have no idea how many people were in their graphics department. Don't know if any of them are actually qualified to do that as well. We don't even know who those people are at this point. Now, issue number 3 is an identification issue. Now, Your Honor, I believe, well, not I believe, I mean, it's pretty much common that the reason the state did this is because there are parts of certain videos that, I mean, it's outside, so it's dark, and there's a distance, and there are a bunch of people, a bunch of things walking around. I believe one of the arguments the state's going to say is the alterations, the changes, well, I don't know if they're deletions or not, but the modifications that they took part or that they did to create this compilation and to create these still photos and to create all of these circles and markings, they did it not to change the substance of the video, but just to give an identification, to make it clear of who they want, what I believe the jury to believe is the actual shooter that killed that little girl. There's a huge problem with that, Your Honor. Number one, when it comes to identification in Georgia, there are ways to work around that. Or I'm sorry, there are procedures that have to be in place before they can put a witness up there that could testify to that, especially when it comes to a video that's blurry. So the first one, Your Honor, part 1, is who can actually make that identification. Part 2 is how can they make that identification, and part 3 is when can they make it. So for starting with part 1, Georgia law, someone who personally knows the person being identified. So in this case, it's someone who personally knows Mr. Conley. They can get on the stand, look at a video that's blurry, and says, yes, I know that's Mr. Conley, or yes, I know that's somebody else. Again, I would like to turn the court's attention to Mitchell v. State, 320 Georgia 673. I already spoke about under Rule 701 in lay witnesses, so I'll skip to the next part. Such lay opinion testimony may include a witness's identification of a defendant in surveillance photographs or video recordings, at least where there is some basis for concluding that a witness is more likely than the jury to correctly identify the person or the defendant as the person in the photo or video. One such basis is the witness's familiarity with the defendant's appearance. In most cases, the opportunity to observe a person's mannerisms, gait, and similar characteristics depicted in video footage will increase the likelihood that a lay witness familiar with the defendant will be better equipped than jurors to identify the defendant from such images. A lay witness with such familiarity would be in an even better position than jurors to identify the defendant where the video was of such poor quality that the average juror would not be able to distinguish the faces by themselves. Investigator Teague is not the person that can do that. And Detective Shephard is definitely not the person familiar enough with Mr. Conley to be able to identify somebody better than the jury can. They are not proper witnesses that can do that. Part 2, someone who was a witness or victim on the scene during the actual incident. I would like to turn the court's opinion, or turn the court to Pearson v. State, Pearson v. State, 311 Georgia 26, a 2021 case. It is improper to allow a witness to testify as to the identity of a person in a video or photograph when such opinion evidence tends only to establish a fact which average jurors could decide thinking for themselves and drawing their own conclusions. The video in this case, however, does not clearly show the man's face, so it would have been difficult for the jurors to identify the man. By contrast, Frazier, who was the witness that took the stand and made the identification, was familiar with the appellant, was a witness to the events in the video, so her testimony was not based merely on her opinion of whom she saw on the video, but also her recollection of what she experienced in the parking lot. So in this particular case, Your Honor, this witness not only saw the video and said, yes, I can ID the person, she was actually a witness on the scene when the video was taken, and her testimony wasn't based just off the video. It was based off of something more than the video. Again, Investigator Teague is not that person. He was never in that position to make that identification, and Detective Shephard definitely wasn't there. He's not in the position to make that identification. So part 3, when we come to law enforcement and non-experts, because again, Detective Shephard hasn't been qualified as an expert under 702 Daubert. So right now, he's still considered not a, I would say lay witness. I'm not sure if we can call cops that, but a non-expert. And I'd like to draw the court's attention to United States v. Wiley, W-I-L-E-Y, 78 F. 4th, 1355. That is a 2023 11th Circuit case. We have explained that lay opinion identification testimony may be helpful to the jury where there is some basis for concluding that the witness is more likely to correctly identify the defendant from the photograph than is a jury. On the one end of the spectrum, familiarity derived from a witness's close relationship to or substantial and sustained contact with the defendant weighs heavily in favor of admitting the witness's identification. On the other hand, knowledge of the defendant's appearance based entirely on the witness's review of photographs is not based on anything more than the evidence the jury would have before his trial. Now, Your Honor, in this case, well, basically, let me back up. What this case basically says is an officer that looks at a surveillance video, it says, well, I think this is somebody, so I'm going to identify that person as somebody in front of a jury. You can't do that. There has to be more than that. In this particular case, United States v. Wiley, the court went on to say some of the officers couldn't identify him because all they did was look at a video, and that's not enough, because that's what the jury's supposed to do. But they did say that there was one or two officers that actually shortly after the incident happened, shortly after the video was recorded and received, they were actually present and arrested the defendant. So they saw the video after they already saw the defendant in short time, and they could identify as this is the person that we believe we arrested. Detective Shephard still can't do that. Mr. Regis actually, I don't want to jump to it. So the point is, Detective Shephard, all of the information that was received throughout this trial, and all of the information that we know Detective Shephard received was a black guy, may have had a mask, well, no, not may have had a mask, did have a mask, but we're not sure exactly which kind. Could have been a COVID mask, could have been another mask from a bounty hunter. Dressed in all black, one had a white t-shirt on. No one ever described what or at least there's no testimony that any witness ever described what Mr. Conley looked like or what Mr. Conley was, or how he was dressed. So before Mr. Conley, and I'm gonna go talk about the press conference he gave. Before Mr. Conley gave that press conference, the only identifications for the actual shooter were black men that didn't look like him and clearly weren't dressed like him. Then Detective Shephard, we all saw that the state brought in the Tom Jones? Yes, Mr. Tom Jones as a witness. We saw the interview, we saw the press conference, we see what Mr. Conley looks like. So at the point where what Wiley says is the officers close in time to getting having the incident happen, getting the recording, and arresting the defendant, Detective Shephard isn't that person that can bring that information in as well. Now, I believe what the state's going to say is because it was dark, because you can't see everything, that we're just assisting the jury in determining who did what. Well, that's not how that works, Your Honor. What they're actually trying to do, again, is trying to put an officer on the stand, Detective Shephard, and bolster his testimony by saying, I believe this is Julian Conley. Let's follow Julian Conley, or the person we think it is, and we believe that's the person that shot him. That's not how evidence is supposed to work. This isn't like they blew up a picture and just made it a little bigger for them to look at. This isn't even in certain instances where you lighten a picture so you can kind of see something else. They're leaving the video, the quality of the video the same. They're just literally circling it and pointing arrows at this person and saying, hey, this is Mr. Conley. He's the one that did everything. They haven't presented a single witness that can actually do that, and that starts at the very beginning when it comes to foundation. Now, also, Your Honor, I believe the state may make or take the position that this happened so many years ago, and Mr. Conley's appearance may or may not have changed. He doesn't look like the same that he looked back then in the video. Well, that's not true. In their opening, Your Honor, they showed the video, they showed a picture of Mr. Conley for the MARTA bus, which was like 6 hours before the shooting. You clearly see his face. Furthermore, not only in their opening they showed the press conference, but they literally played the video to where they saw what Mr. Conley looked like after the incident when he gave the press conference with his former attorney. So they can't get up here now and say, well, his appearance has changed, and Detective Shephard knew what he looked like back then and knew what he looked like now, so he's assisting them with that. That's over because the state ended that themselves when they played the press conference. Make sure I don't miss anything or backtrack. So at this point, the state conceded or when we first addressed this issue, that it's not a demonstrative. I believe they're going to get up here and say this is still substantive evidence, and they haven't changed the substance, but that's not true, Your Honor. The substance of a video is what the video actually shows. The substance of a video isn't this is what we want you to look at in the entire video. At the point where they take the entire video, they splice it up to show the jury what they want the jury to see. They circle certain people that we can't or that they can't identify, and they possibly can't know who it is. They point arrows to the person, put words underneath, and then follow that person. That changes the substance of the video. And because for all of those reasons, Your Honor, until we know exactly what happened, exactly who touched it, exactly how it was used, exactly how many hands it passed through, and exactly a witness that can lay the foundation and go through all of these steps that the state created by changing these alterations, we believe that State's Exhibit 2, the way they're trying to introduce it, is inadmissible. Now, if they want to introduce the raw video that they got from the BP, the liquor store, and the warehouse, we are fine with that. But anything other than that, Your Honor, we're going to need a day to argue all of this with their witnesses after we talk to our people to figure out what was done. So for those reasons, we're asking that you keep out all of the alterations and only bring in the quote-unquote raw data that was received at the beginning.
Do you agree that they could play the raw data and zoom in as they show that on the computer?
Yes, in front of a jury, yes.
Okay.
However, yes, they can do that, but I do not believe that once they do zoom in, they can say, this is Julian Conley doing ... That's for the jury, unless they can show some type of familiarity to prove that, to show how they know that's Julian Conley.
Do you agree that these witnesses could testify that the person in the video resembles Mr. Conley?
Well, that's the question. Which witnesses?
I'm asking you.
No. And
You don't think any of the law enforcement could say that?
I believe that they can say that that is Mr. Conley in the MARTA bus. 100% I believe they could say that. I believe that they can say that that's Mr. or someone that resembles the clothing, kind of the clothing that Mr. Conley was wearing in the parking lot. After that, when they're doing circles and pointing arrows, absolutely not. You cannot see who that person is. The only people that would be the people that were actually there during the incident.
And if they characterize particularly the still photograph with the circles on it, if they characterize that as a demonstrative, how would that change your argument, or would it at all?
Well, then it would go under a 403 analysis. And I really can't answer that until I know which witness is going to say it, how they have the information to say it. But then we could definitely make a 403 analysis on it.
Okay, thank you.
Thank you, Your Honor.
Judge, do you mind if I just...
Not at all.
So I'm going to start with the argument as it relates to the video being, I guess, altered in the sense that they're not the raw footage. The testimony of Detective Teague is the compilation is the raw footage, but it's the raw footage from the 3 different locations next to each other. So it's like playing 2 separate TVs side by side. So if you want us to bring in another big screen, we can play them both at the same time, because that would be what this is equivalent to. It's just playing the BP at 8 o'clock, let's say, for example, and then playing the warehouse video cameras at the exact same time in 2 separate TVs. So if the court wants to give us time to bring in another Mondo board or large TV, we'll be happy to do that. As it relates to the circles that were placed by Detective Shephard around individuals that he believed to be persons of interest as it relates to his investigation. I would give the court United States v. Rowinski, which is R-O-W-I-N-S-K-Y, the 2013 U.S. District Court of Florida from 2013. In that case, the court says, as for the circles and arrows added around pictures and people in the videos, the court does not agree that they constitute hearsay. Rather, the circles and arrows are more akin to summary charts, effectively summarizing the images that the government believes to be relevant from the photographs and the videos, containing numerous people whose presence is allegedly irrelevant to the charges in the case, which is exactly what we have here. He identified people or persons of interest, and he followed those people and persons of interest through the hours of footage that he watched in all 3 of the video systems that he was able to recover. That's all this is akin to. So it's not hearsay. There's no markings that would constitute as testimonial as it relates to Detective Shephard's circles on the video, and more importantly, it doesn't alter the raw footage. The raw footage is the raw footage. It just puts a circle around one of the individuals contained within the raw footage. As it relates to the...
So, hold on one second. So the photograph with the circles and some words on it, that hasn't been altered in any way? That's not... the image itself hasn't been changed by your graphics department?
No.
Other than to add the circles and the words?
Well, the circles were added by the actual photographs that are found in Detective Shephard's report are photographs made from stopping video, screenshotting it, and then putting it in his lead supplement and putting circles around the people he followed as persons of interest.
With marker?
Correct.
Okay.
Or marker in the sense that it's a computer marker, like, yes, with marker, for lack of better word.
Okay.
So there's no alterations as it relates to any of the raw footage as described by defense counsel during his argument. As it relates to the identification issue brought up by defense counsel, I would wholly disagree that this is a 702 issue. It has nothing to do with, this is lay witness testimony that would be more than permissible under 701. I would bring to the court's attention first, Taylor v. State, which is 315 Georgia 630. It's a 2023 case. According to the 11th Circuit Court of Appeals, identification testimony that's based on a witness's firsthand observation of the defendant's appearance is the type of evidence contemplated by Rule 701, and I meant, Your Honor, United States versus Knowles, KNOWLES 889 F3D.
Can I have that side one more time?
Yes, I apologize.
That's okay.
889 F3D 1251. It's an 11th Circuit Court case from 2018.
Okay.
I'd also bring to the court's attention Cross v. State. In that, in Cross, the court makes clear, I apologize. In Cross, the court says, rather than setting forth specific factors that must be present for the admission of identification testimony under OCGA 247701A, the Supreme Court of Georgia has held that such lay witness testimony is admissible so long as there is some basis for concluding that a witness is more likely than the jury to correctly identify a defendant as an individual depicted in the video recording. Then lay testimony identifying a defendant in those video recordings is admissible under 701.
And what's the site for Cross again?
It's 370 Georgia, Appeals 250.
50. Thank you.
And then I'd like to bring to the court's attention a recent case as it relates to the same or similar issue for identification. In United States v. Wilson, 143 F 4th 647, pin site 663. It's a 5th Circuit Court case that just came out July 17th, 2025. It is almost directly akin to the case that we have, or the situation we have in this case, Your Honor. Deputy Atkins' identification of Fernandez and Wilson, the defendants in that case, fits comfortably within the appropriate authority. A specialist in apprehending fugitives, like Deputy Atkins, had become familiar with Wilson and Fernandez's appearance while investigating them. And Deputy Atkins' testimony was particularly helpful to the jury because Wilson and Fernandez were wearing hats and sunglasses in the Instagram photos and videos in which he was permitted to identify the defendant from prior video footage that he had also been able to come in contact with, which is akin to Detective Shephard in this case. He not only looked at hours and hours of video footage, but he also was able to get the defendant's entire Instagram username profile, where he saw hundreds and hundreds of videos and photographs of this defendant. He was also able to get several hundred photos that were sent to him from the bolos that were distributed throughout the media in the city of Atlanta of people identifying the defendant as Julian Conley. And to me, this is almost a moot point because the defendant himself identifies himself as the person in the red from the scene when he gives his interview with his counsel at the time, Mr. Patterson. So
I think they concede that you can prove that he was at the bus. The issue is in the other photographs. Am I speaking out of turn?
I guess that's the confusion that I have, because the photographs, or it's video, because I don't have any other photographs, but it's video where he's wearing the exact same thing in the video, the MARTA video photograph, in which he identifies himself in, making the point moot. And more importantly, during the interview in which he gave with Tom Jones and his counsel next to him, he admitted that he was standing there at the barricade at the time the shooting occurred, which is exactly what Detective Shephard's testimony would be based on his hours and hours and hours of footage that he reviewed from the BP warehouse footage, as well as the package store video surveillance, Your Honor. So based upon all of the case law and the evidence that would come out before Detective Shephard, and I guess the point of admitting it through Detective Teague was exactly what defense counsel mentioned during his argument. Detective Teague is the person who was able to retrieve all of the raw footage, which is exactly what the compilation video is. It's all of the raw footage that is put together. It's not spliced. It's literally the same raw footage from the same time period, playing at the exact same time with Detective Shephard's circles on them.
So in terms of laying a foundation for it, you absolutely had to have that testimony.
Correct.
Okay, do you need a ruling? You want to follow up? You
Yes.
have anything left to say? Okay. And did I cut you off, or were you finished?
I would have been repetitive, so I'm glad you cut me off.
Okay.
I'd first like to say, before we give a ruling, I gave the court and the state my case law a couple of days ago. They're just now telling me these cases. I haven't had an opportunity to look at them yet, so I would like to look at them before the court gives a ruling. Secondly, Your Honor, just listening to the state's argument, I still don't believe that they're on the same issue that we are. It sounds like one of their cases, the officer that was on the stand was a specialized officer who specialized in investigating people, and he's bringing that information in. They haven't presented any information that Investigator Teague or Shephard are specialized in anything other than collecting videos and altering them. Another issue, Your Honor, is I still don't know what type of videos those cases that the state quoted were talking about. I'm specifically talking about the videos that are akin to ours. It's not 100% true when the state says they're just putting two separate videos up side by side together. Your Honor, at some points there's like a 6-hour gap in between when you see or when they want you to see Mr. Conley, and then when they want you to believe who you're looking at as Mr. Conley is now. Secondly, Your Honor, yes, we can see he was there at the MARTA station. You see exactly what he's wearing. The state says, well, you can still see what he's wearing in other pictures. That is not true. The person that they're circling and literally pointing an arrow to, you can't tell what the color of the clothing is, like the state's trying to tell you. So that tells me that I don't believe their case law is on point as close to ours. Also, Your Honor, in the press conference, it's not true that when the state said Mr. Conley said that he was right there at the barricade when it happened. Mr. Conley admitted that he was at the scene, and I believe we have witnesses that are going to testify and show that that's actually true. He was at the scene, but he was not at the barricade when it happened, and he's definitely not the person that the state circled and is pointing an arrow to. And I think the biggest thing, Your Honor, is at the point where you take raw video footage, and then it passes through the hands of multiple people in multiple departments, so you can bring it in to show that shows there's some type of specialized knowledge. We still have I am not able, and Mr. Regis is not able, Ms. Broderick is not able to properly cross a person when we don't know what happened with this specialized knowledge. The simplest way I can look at it, Your Honor, is if I'm a third grade teacher and I'm teaching math, you want your son to know math. If I just tell your son 2 + 2 is 4, substantively, I have not changed math. 2 + 2 = 4. But he didn't take the steps to get to it. That's what evidence is. We present evidence to give the jury the steps to get to it. If we allow the state to bring in a video, circle it, put an arrow on it, and say, this is Julian Conley, they're boasting this is Julian Conley without allowing them to take the steps to get to it. So for those reasons, I would like to research their cases before you give a ruling, and I can do that. Shepherd's next?
No.
then I should be able to do that
I want to
before
look at them
Shephard
too,
takes.
so to put your mind at ease, I'm also going to look at his cases. But do you agree they could do that in court? Do you agree that playing the raw footage, the detective could circle it on the screen and then they could print that?
100%.
Well, that would just, if you want to add hours to his testimony, that's fine. But if 2 + 2 = 4 always, and all the state is doing, you've got 2 + 2 that's a little bit smaller, and then you zoom in and you still have 2 + 2. It's just a larger version of 2 + 2. The 4 is still the same. And the 6 hours of footage that he claims that were spliced, and that's when you see the defendant. The MARTA video is taken at 9:13 p.m. The shooting is at 9:46. We're at less than a half an hour to when the defendant is seen in the exact same clothing that he is in the MARTA and at the barricade. And to be clear, during the interview, Mr. Patterson and his client say that he is at the barricade, he is there when the car goes by, that he witnesses, allegedly, one of his friends get hit by the car, go down, get up, and start to shoot. And he would be able to testify to that, or he would be able to tell whoever he needed to say as it relates to that, but he's choosing not to say anything further as it relates to the investigation, were the exact words of the interview by his agent.
Okay, let's all look at those cases and we can take this up later. I don't want to overcomplicate it. The purpose of the authentication statute in Georgia is that we don't have to bring the camera maker, we don't have to bring whoever developed the photograph. We have to have, though, a witness who can properly authenticate. So let me look at these cases and see where we are. Okay.
And Judge, if I just may, depending on what your ruling is, Mr. Patterson is here, that may change.
Right.
how we move.
Are you calling Mr. Patterson, or
May
he's your
likely-
witness?
We may likely be calling Mr. Patterson.
Okay.
He's in the United States.
Okay, I thought he was just observing. Thank you. Okay, are we ready with a different witness that doesn't require this?
Yes.
Okay.
But we should probably bring to the court's attention the witness is it's a short GBI witness. That's the witness that was scheduled to testify prior to.
What's the nature of its expert testimony?
It's GSR.
Okay,
Yeah.
so it will be quick. Okay, that's fine. You want to bring the jury out? Okay.
On back to the jury.
Yeah, 105 is the report. It's already been tested.
Judge, that kind of sworn.
Good morning. Thank you for your patience while we argued some legal issues. Hopefully that'll make the day run a little more smoothly. We are probably going to have to send you out for a few minutes at some point this morning, but we're going to go ahead and hear from our first witness now.
They were called Alexander Coven.
Swear affirm the testimony you give to the court that you will go ahead and have a seat in the United States. Spell your name.
My name is Alexander Coven, Alexander C-O-V as in Victor, I-N.
Good morning, Mr. Coven.
Good morning.
Can you tell the jurors how you are currently employed, sir?
I am a scientist, a microanalyst in the trace evidence section at the Georgia Bureau of Investigation, Division of Forensic Sciences, commonly known as the State Crime Lab.
And can you tell the jurors how long you've been employed by the GBI or the Georgia Bureau of Investigation, the State Crime Lab?
About 10 and a half years.
And of those 10.5 years, have you always worked in the position of a microanalyst in the trace section of the GBI?
No, for maybe the first 9 or 10 months or so, I was a lab technician in the trace evidence section, and then I was promoted to the scientist position.
And can you tell the jurors, what is the trace evidence section of the GBI, Georgia Bureau of Investigation?
Trace evidence deals with any areas of analysis, a multitude of which are dealing with gunshot primer residue, or GSR, paints and coatings, plastic, tape, hair, fiber, glass, fractured materials, and a lot of general unknowns.
And if you could, for the jurors, Mr. Coven, explain to them your educational background and training that you've received that allowed you to work in that area of science.
I received a Bachelor of Science in Chemistry from Albany State University, and upon being hired at the GBI and promoted to the scientist position, I started a training program, and the way we do it is whatever area of analysis we need examiners in, that's what you're going to start your training in. And for me, it was GSR. And so that was about a 6-month-long training program, like going back to school again, lots of reading, exercises, tests. And then once that was complete, about a 3-month-long supervised casework phase where I was doing real casework, but my trainer was going through some of the technical steps with me as well. And when it comes to every area of analysis that I'm trained in, that's a similar training program that I have to go through.
And you mentioned specifically, I know your few seconds ago, your testimony that trace evidence looks at paint, things, GSR, gunshot residue, and other items of trace evidence. I want to specifically talk about what you just described, that you received specialized training on GSR, gunshot, residue, analysis and testing. Can you tell the jurors what gunshot residue is and the training that you received specifically to identify or attempt to identify gunshot residue and items of evidence that you received?
Gunshot residue, gunshot primer residue specifically, which is what we are looking for in these types of examinations, are a collection of microscopic particles that are created when a firearm is discharged. This plume or cloud of vaporous gases are formed when a firearm is discharged and kind of behaves like a plume of flour or baby powder, if you will. These particles that we're looking for are invisible to the naked eye. Molten discrete particles containing all 3 of the elements lead, barium, and antimony. And they have the ability to settle out or land on any surfaces in close proximity to that firearm that has been discharged. And as far as the training for GSR, again, it was a 6-month-long training program, like going back to school. And over the years, we stay abreast on any new research, journal articles coming out that pertain to the science. And we are also proficiency tested on a rolling basis, maybe every 1 to 2 years, to make sure that I'm still proficient in doing GSR analysis.
And I know you said the first 9 to 10 months of your employment with the GBI, you worked as a technician in the trace section, but you were then promoted to the scientist level. Can you tell the jurors in those 9 years you have been a scientist, have you always worked in the area of GSR, gunshot primer residue analysis and testing?
Yes, I have.
And I think you just mentioned over the years, as you continue your employment, you also continue your training relates to that specific area of science, doing the trace evidence area.
Yes, I did.
And you had an opportunity in the last 9 years to testify
Yes, I have.
And have you, during the times you've testified on GSR, have you been qualified as an expert during the times you've testified?
Yes, I have.
Your Honor, this time the state would tender Alexander Coven as an expert in gunshot primer residue.
Any objection?
No objection, Your Honor.
He's so qualified.
Thank you, Judge. Now, you, a few minutes ago, kind of explained what gunshot primer residue is and how it's created. Now, can you tell the jurors how you received the evidence that you attempt to test for the residue that you talked about?
Any law enforcement agency in the state of Georgia or DA's office can submit evidence to the Georgia Bureau of Investigation Division of Forensic Sciences. And typically that will come in through our evidence receiving section, usually through the lockbox system. And that is a wall with a row of lockers in it where somebody can open one side of the lockers, deposit the evidence, and once that locker is closed, no one else has access to it, except for our evidence receiving technicians on the other side of that wall. They will then take that evidence, get any proper documentation that came with that evidence, and create a GBI-specific case number for it, itemize all of the evidence that came with it, and route it throughout the laboratory to any section where the examination for that evidence is needed.
And before we get into the evidence that you received as it relates to this case, can you tell the jurors, you talked about the process and how gunshot residue is scattered or dispersed from a firearm, but can you tell the jurors where on a person or an object that gunshot residue can typically be found because of that plume of, for example, you said like baby powder as it expands?
Where on a person or object. So, for instance, if you are a shooter and you discharge the firearm, the GSR particles will be landing or settling out on any surfaces in close proximity to that firearm, to include you yourself if you're the shooter. So mainly your hands and maybe the front side of your body, so your clothing items. And then, of course, again, anything that's in close proximity to that discharging firearm.
Okay. And I want to direct your attention. Can you tell the jurors when evidence is received, like you talked about, does the GBI create a unique case number for every piece of evidence received as it relates to a specific case?
There will be one case number created, and then each piece of evidence will have its own item number.
And as it relates to GBI case number or DOFS case number 2020-1017123, did you receive evidence as it relates to that case?
Yes, I did.
And can you tell the jurors what evidence did you receive related to that unique case number?
I received a GSR collection kit identified as used to sample a Jeep headliner.
I want to show you what's been previously admitted into evidence. Exhibit 104. You can already open, you can look inside of the bag, sticker on it.
Okay.
It's states in the 104, the kit that you received, you just described you received as it relates to the GSR testing and analysis that you did.
Yes, it is.
And can you tell the jurors from looking at states in the 104, kind of explain to them a little bit about the process, about how the GSR was collected as it relates to the materials or the tests that you received in 104?
Typically, a person's hands or any item that you believe may have GSR on it can be sampled for GSR, usually using one of these GSR collection kits. These kits contain 3 stubs, what we call stubs, which is a 1/2 inch in diameter metal disc with black carbon adhesive tape on the top. And so any surface that you think has GSR on it, you can take those stubs and dab and sample that area for GSR, and any particulate matter that is there can be picked up. Typically, you would have a right-hand stub, a left-hand stub, and then a control stub. That control stub is not to be touched to anything. It's just to be exposed to the collection environment, showing that there's no extraneous GSR in the collection environment, which can also be carried throughout the entire examination process with me at the laboratory. Like I said, usually it's a hand kit, so a person's hands would be getting sampled for using these kits, but in some cases, like in this one, a vehicle can be sampled and the labels for right hand and left hand can be scratched out, and you can, if it's deemed necessary, specify what area you sampled using those stubs.
And is that what was done here as it relates to, I think you previously said it was the headliner?
Yes, so for this particular case, it was identified to me on the front of the kit that it was from a Jeep headliner, but the stubs themselves didn't have any additional information on it.
And in the information that you received from the evidence receiving technician for the GBI, can you tell the jurors what agency the evidence came from?
This came from Atlanta PD.
And can you tell the jurors when you receive evidence and do your testing, do you memorialize your findings and conclusions in a report?
Yes, I did.
Okay, and did you do that in this instance?
Yes, I did.
And does that report that you memorialize your findings have the unique case number that we talked about specifically for the Georgia Group investigation?
Yes, it does.
And do your reports typically not only contain your number and your analysis and conclusion, but does it indicate who, I guess, provide the agency, detective who's requested the specific testing?
Yes, it does.
Does it involve the case number as it relates to the agency here at APD that provided you the evidence?
Yes, it does.
Now I want to show you what's been pre-marked for identification purposes. 105. You will take a look at that and let me know you're done just by looking up.
Okay.
Mr. Coven, do you recognize State Exhibit 105?
Yes, I do.
Can you tell the jurors how you recognize it and what it is?
This is my GSR report for this particular case. I recognize it by the Division of Forensic Sciences seal at the top, the GBI specific case number that we mentioned earlier, as well as my signature at the end of the report.
And is that a copy of the same report you created as a result of the analysis and testing that you did from the evidence contained in State Exhibit 104?
Yes, it is.
This time around, the state contender was remarked State Exhibit 104 evidence.
Any objection?
No objection, Your Honor.
It's admitted, and you can display it.
Thank you, Judge. We play hide and go seek with the courts. I want you to talk a little bit about, you've talked about what GSR is and how it's created. Can you explain to the jurors, once you've received the evidence, kind of the process that you go through when doing the testing and analysis to determine if there's a presence or lack of presence of GSR?
Once I am assigned the case, I will retrieve this evidence out of our evidence locker in the trace evidence section and begin my examination using a scanning electron microscope equipped with an energy dispersive X-ray spectrometer, or SEM-EDS for short. And all that is just a very high-powered microscope that uses a strong beam of electrons instead of light, like how you would usually see with a biology class microscope. This instrument allows me to see what is on the surface of that black carbon adhesive. So any particulate matter that was picked up, I could see it and image it. And then this instrument also allows me to get an elemental profile of what those particles are made of. So again, I'm looking for small, discrete, molten particles that contain all three of the elements, lead, barium, and antimony, to be characterized as GSR.
And
This GSR collection kit that contains samples from the Jeep headliner failed to reveal any particles characteristic of GSR.
Now, can you tell the jury, based on your experience, number of years of experience with the trace evidence section, specifically in gunshot primer residue, can you tell the jurors, and based on your training, what does the lack of, in your opinion, of GSR indicate to you from your expert opinion?
That indicates that either this vehicle was not in close proximity to a firearm itself when it was discharged, did not touch something that had GSR on it to transfer to this vehicle, this Jeep headliner, or the GSR particles, if they were in fact there at one point in time, they were lost before this headliner got sampled for GSR.
Hypothetically, if in this instance the headliner from the Jeep that was collected and submitted for testing, if a firearm was fired inside of the Jeep with all four windows up or down, the firearm was fired from inside the Jeep, would you expect to find GSR particles in your analysis after you tested the evidence?
If a firearm was discharged inside of a closed vehicle and that vehicle was not cleaned or washed before being sampled, yes, I would expect to find GSR inside of that vehicle.
Would you also expect to find GSR in that vehicle, even if a firearm is discharged and let's say one of the windows is down?
And it was discharged inside of the vehicle?
Yes.
Yes, I would still expect to find particles of GSR at that point too.
And after doing your analysis on the evidence that we talked about in States Exhibit 104, did that complete your part or your role as it relates to the testing of the evidence that was submitted to Georgia Bureau of Investigation?
Yes, it did.
Thank you for your time, Alexander.
Cross-examination?
Very, very briefly. If that arm was outside the window and that car is moving and there's a hot, humid July night, you would not expect to find GSR inside the vehicle, would you?
It's difficult to say because every situation is different. I wouldn't be surprised if I found a small amount of GSR just because that plume could still have the possibility of coming inside of the vehicle with that rolled down window. But a large amount I wouldn't expect to find, no. And different circumstances can cause you to maybe not find any GSR there at that point.
So, with that arm outside that window, as that car is traveling, let's say 20, 30 plus miles per hour, you have whatever GSR there might be impacted by wind, correct?
That is correct.
You have whatever GSR there might be impacted by humidity, correct?
I would reasonably expect so. We haven't had a lot of studies on that, if at all. But that's reasonable to expect that the humidity may be able to affect that plume itself, how large it gets and where it goes.
When you have that barium, antimony, and lead, they can be impacted again by wind and weather and environmental factors, correct?
Yes, it can.
And in terms of where that GSR could go, it could also be impacted by the type of weather, correct?
Yes, it can.
For example, a 22, it does something funky with the GSR. It doesn't even shoot the same pattern, isn't that correct?
That's correct. The plume is different at that point.
Without knowing the type of weapon, you don't know the likelihood of finding GSR on a headliner, do you?
Sometimes I am given an indication of what kind of firearm was used and the ammunition. In this particular case, I have the information with me, but I don't have it memorized.
And with that arm being outside that window of that moving car on that July 4th humid Atlanta night, you would be not at all surprised if there was 0 GSR inside that car. Isn't that correct?
On the headliner, no, that would not. That it's fine to. It's reasonable to expect that you wouldn't find GSR on the headliner, the roof of the vehicle, if this is the scenario that I'm being provided with.
And all they gave you were a few samples from the headliner, correct?
That is correct.
No further questions.
Based on your training and experience, is it reasonable to expect to not find or a lack of presence of GSR if the circumstances where a gun wasn't fired in the car?
That is correct. If a gun was not fired in the car, I would not expect to find GSR, and I have not found GSR in circumstances like that.
And if in the scenario that defense counsel just walked you through, if somebody hypothetically had shot out an open window, would you expect to find GSR on the door area where the window is open?
Yes, that is possible to have some of the that plume deposit right on that door area. Yes.
Even when it's a hot, humid July night?
Even in those circumstances, yes.
Even when there's wind on that hot, humid July 4th night?
Correct, yes.
And would you expect to find GSR in a car if, hypothetically, someone indicated that the driver rolled down the passenger window and pointed across the car and shot out the passenger window? Would you expect to find GSR on the headliner?
In that scenario, yes, I would absolutely expect to find GSR.
I want to be clear, your testimony was that in this instance, from your testing, you did not detect any GSR found in the items of evidence that were presented to you that were collected from the Jeep.
Correct, no GSR.
Nothing further, Your Honor.
And I just need to be clear again, I apologize. What items were tested?
In this particular instance, the headliner of the Jeep was tested for GSR.
What about the outside of the vehicle as far as you know?
The outside of the vehicle was not tested or sampled for GSR.
Thank you, sir.
Well, let me ask you this question. It's my last question, I apologize.
It's
if
okay.
A car is under attack and as it drives by, one or multiple individuals shoot into the driver's side of the car, would you expect to find GSR on the outside of the vehicle because it was hit by bullets?
Yes, I would expect to find GSR there. It gets a little tricky with the outside of vehicles because, again, this is exposed to the elements. I don't know how quickly this vehicle got sampled or any vehicle in that instance would get sampled. Like if it rained before you sampled it for GSR, you might lose those particles. The outside of a vehicle is not something that's going to just hold GSR particles very well, like a cloth material or a person's hands. But yes, the GSR would be deposited on this vehicle if it was shot at on the outside of that vehicle. How long those particles would stay there, I can't say for sure.
And let's say in the example you just gave, the testing was done and you didn't find GSR, but you saw at least 8 bullet holes in the car. Based on your training and experience, would your conclusion be the car was shot by bullets still?
Yes, me not finding and still not finding GSR, I'm sorry.
Yes.
Yes, me not finding GSR on the headliner of this Jeep, even when it was shot multiple times, that would not change my thinking or my conclusion that this vehicle was shot, because those GSR particles would not necessarily have the best possibility to get on the headliner if you're shooting through the outside of the vehicle. Most particles of GSR would be deposited on the outside of that vehicle, not inside.
One question. know, in looking at your report, State's Exhibit, yes,
105.
105.
State's Exhibit 105, it has the word conclusion, it has the word conclusions in it. But the lack of gunshot residue on that headliner is not, despite the word conclusion, is not conclusive of a gun being fired outside the window. Isn't that correct?
There are many possibilities that could explain why no GSR was found.
Again, I want to make certain, I apologize, my question was not clear. Despite the word conclusion, it is not conclusive. Is that correct?
It is a conclusion, but I cannot tell you which of these conclusions is the correct one.
So it is not conclusive, correct?
It is a conclusion that I created, and there's 3 or 4 different possibilities in that conclusion, and I cannot tell you which one of those, based off of the information I have, is the correct, what actually happened.
And to be clear, you work for the Georgia Bureau of Investigation's crime lab, correct?
Yes, I do.
You are part of law enforcement, correct?
We can be viewed as part of law enforcement, although we are separate from law enforcement.
Isn't it correct, the very website says you exist to give cutting-edge technology to assist law enforcement?
That is correct.
No further questions.
Anything else?
You may be excused, Your Honor.
Okay, thank you for joining us. Thank you, that's okay. Thank you for joining us, and you can be excused.
Thank you.
Can I see the lawyers at the bench?